I thought you conceded to Justice Gorsuch there was no difference between a tariff and a licensing fee functionally.
If the licensing fee is just to, I didn't concede that. So if the licensing fee is just to recoup the cost of government services, I think that may be okay. I don't think you need to get into it. Here, the government is asserting a power which they say in their briefs to you raises $4 trillion.
So this license thing is important to me. And do you agree that pursuant to IEEPA, the president could regulate commerce by imposing a license fee?
I'm sorry, could you say that again?
Could the president regulate commerce under IEEPA by using a licensing fee?
Not a fee. So I should have said this earlier, but license is different from a licensing fee. IEEPA and TWIA authorize licenses, not license fees, and no president has ever charged, to my knowledge, fees under those two statutes for the licenses. So fees impermissible, licenses okay.
Fees permissible if they cover the costs of the scheme?
Might be. I mean, but once they start revenue raising, you implicate the most serious concerns.
But I thought you conceded to Justice Gorsuch there was no difference between a tariff and a licensing fee functionally.
If the licensing fee is just to, I didn't concede that. So if the licensing fee is just to recoup the cost of government services, I think that may be okay. I don't think you need to get into it. Here, the government is asserting a power which they say in their briefs to you raises $4 trillion.
So you understand the statute to permit licensing in the sense of permission. Like, we will not allow you to trade with us. We will not allow your goods to be imported unless we license it.
Absolutely. And Justice Barrett, I think like just the natural reading, if you're to look at the word licenses and think, wow, Congress smuggled this incredible power to do all of these different things that the government is doing here, 39% taxes on some countries and others, through the word license, that's
Can you license exportation?
I don't think so, for the reason that,
Well, right now, I actually looked into this. I mean, I think you, maybe not licensing fees.
Exactly.
But could you license exportation, like saying we're not going to allow certain products that have national security implications to be exported?
Yes.
So licensing could be used in that sense,
Correct.
not as a revenue raising measure.
Yes.
Okay. So you went back and forth with Justice Gorsuch about the implications of the president's authority over foreign affairs and whether the major questions doctrine applies. You say that in IEEPA, the president's war powers are not implicated. And that was part of the reason why you say that we should think of this differently than some of the historical examples where the commander-in-chief power, war powers, were implicated. But the same language appears in the Trading with the Enemies Act, in which war powers would be implicated. So do you think the language should be, and of course that is what President Nixon relied on. So do you think that the language would be interpreted differently in that context, even though the commander-in-chief power and the war power would be implicated?
100%, I think, would be interpreted differently. Justice Jackson.
Same regulate commerce language.
Yes, because once you're carrying over wartime precedents to peacetime for reasons.
Okay, I don't understand that then, because everybody agrees the language came in IEEPA came from the Trading with the Enemy Act. So you're saying it has one meaning in the Trading with the Enemy Act and a different meaning in IEEPA, that same regulate commerce?
No, I think that the conquered territory language and all of that may go to the president's Article 2 powers as inherent powers in conquered territory, but I don't think it gets the government where they need to go. The CAC brief and the brief by Professor Paul Stephen goes through and explains why in 1933, when Congress decided to bring these concepts into peacetime, it severed the wartime roots. And there's an extensive legislative history.
Okay, I understand that, but I thought that was about, maybe I'm just not tracking. I mean, I think there's been some discussion of whether the president would have inherent Article 2 authority in wartime to impose tariffs to this end. Is that what you're talking about? Are you actually talking about a statute that said regulate importation in wartime? Right. And you think it could have the tariff power conferred through that language in a war-making statute, but not in IEEPA?
No, I don't think it confers it in either place. I think the president, the president's power in conquered territories, not in the Trading with Enemies Act or anything like that.
Okay, so it's an inherent constitutional power coming from the law of war. Okay. And then if you win, tell me how the reimbursement process would work. Would it be a complete mess? I mean, you're saying before the government promised reimbursement, and now you're saying, oh, well, that's rich. But how would this work? It seems to me like it could be a mess.
So the first thing I'd say is that just underscores just how major a question this is. The very fact that you were dealing with this with quotas, there's no refund process to the tunes of billions of dollars or embargoes, but there is here. But for our case, the way it would work is, in this case, the government stipulated for the 5 plaintiffs that they would get the refunds. So for us, that's how it would work. Your question, I take it, is about everyone else. We don't have a class action or anything like that. With respect to everyone else, there's a whole specialized body of trade law, and it's in 19 U.S.C. 1514 outlines all these administrative procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with in the United States Shoe, in which the refund process took a long time. There were any number of claims and equitable relief.
So a mess.
So it's difficult,
okay.
Absolutely. We don't deny that it's difficult, but I think what this court has said in the McKesson case in 1990 is that serious economic dislocation isn't a reason to do something. Northern Pipeline, you guys stayed your decision for a while in order to let the congressional process unfold. There may be a congressional process here as well. You may be able to also be that this court could limit its decision to prospective relief under the John Q. Hammonds case. So there's lots of possibilities.
Justice Jackson?
So I think I read Algonquin differently than Justice Kavanaugh. When I look at its analysis, it absolutely does a textual review, but then it says, quote, turning from Section 232's language to its legislative history, again, there is much to suggest that the president's authority extends to the imposition of monetary exactions. And I appreciate that perhaps that factor is no longer in vogue, but did you look into the legislative history here to determine whether there is anything that supports the conclusion that Congress actually intended for this IEEPA statute to allow or authorize the president to impose these tariffs?
I did, and if I blinked, I would miss it because it was virtually nothing. And in fact, both page 2 of both the House and Senate report outline all of the powers that are given under IEEPA, and none of them have tariff. There's one brief mention of tariff in the legislative history, but nothing else. And by the way, IEEPA passed by voice vote. It was, there was not controversial. We don't deny IEEPA as a big, major statute, but the question is, did it authorize tariffs? One of the most contested things since our founding.